This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Federal Trade Commission and 17 states are suing Amazon over allegations the e-commerce giant abuses its position in the marketplace to inflate prices on and off its platform, overcharge sellers, and stifle competition. The lawsuit is one of the most significant legal challenges brought against Amazon in its nearly 30-year history, accusing it of monopolizing online marketplace services by degrading quality for shoppers and overcharging sellers. The case also represents a career-defining moment for FTC Chair Lina Khan, who's long had Amazon in her sights.
So look, this case is entirely pro-business. It is, tens of thousands of businesses that are dependent on Amazon to reach shoppers that increasingly are paying $1 out of every $2, as well as being subjected to all sorts of, arbitrary tactics. So we believe that this lawsuit, if we're successful, will actually entirely restore the promise of free competition. Our free enterprise system is one where companies should be competing on the merits and not be able to protect their monopoly power through illegal tactics.
Joining me is Jennifer Rhee, Bloomberg Intelligence Senior Litigation Analyst. Jen, this lawsuit comes as no surprise.
Oh, not at all. I mean, we've all been expecting this for years. The investigation of Amazon actually started during Trump's FTC, and it was already ongoing when the current chair, Lina Khan, took her position, which was back in 2021. And when she did, it was sort of widely thought that she was hired partially because of her very overt, outspoken antagonism toward Amazon. She had written a long article in 2017 while in law school, or at least for the Yale Law Journal, basically saying that she thought that Amazon behaved as an anti-competitive monopolist. So this is no surprise at all.
So tell us what the FTC and the 17 states are accusing Amazon of.
They're really focusing on its marketplace, right? Because Amazon has other businesses outside of what we as consumers know of Amazon. So they're focusing on the way Amazon treats sellers. And they're essentially saying that some of the policies and some of the conditions they impose on these sellers, one, cause prices outside of Amazon to go up. In other words, sellers, if they discount a product where they're selling somewhere outside of Amazon, more so than they have on Amazon, haven't offered Amazon the lowest price that they offer, that seller then gets punished. That's one thing. And they also allege that Amazon punishes sellers by sort of pushing them down in search results or taking them out of the buy box if they don't use Amazon's fulfillment services. That's using Amazon to store the product, package the product, and send the product when somebody buys it. So it's really all about sort of unfair treatment of the sellers that are on the marketplace.
And it's really important where you are in those Amazon searches, because a lot of people don't get past the first two or three.
Right.
Lina Khan said, Amazon is a monopolist and is exploiting its monopolies in ways that leave shoppers and sellers paying more for worse service. But are shoppers paying more? Because I find that the prices on Amazon are often cheaper than they are elsewhere.
Well, of course, that's exactly what Amazon's defense is going to be. No, we offer convenience and speed and low prices. And part of the reason that we have some of our policies in place that require these sellers on our platform to provide the lowest price on Amazon is because that's what our consumers expect. That's what we've held ourselves out to be, the lowest price that you can get out there in the marketplace. And this is pro-competitive, not anti-competitive. But on the other side, there may be some evidence that because it's a little more expensive for a company to sell a product on Amazon than some other website, let's say Etsy or their own proprietary website, that they end up raising the price outside of Amazon on those websites because if they have to offer the lowest price on Amazon, they don't want to kill their margins selling on Amazon. So instead of lowering the price everywhere, they're increasing it outside. So people who bought that product outside of Amazon are actually paying a higher price. And I think that's part of the allegation of the increased prices.
Amazon is a monopolist. Is that accepted that it's a monopolist or not?
Yes and no. The thing about antitrust law is whether or not you're a monopolist all depends on how the market's defined. You have to look at the contours of the market. What is the market you're competing in? Now, I think the FTC in this lawsuit's basically provided two market definitions. One is the consumer side. It's a broad online marketplace to buy all sorts of goods. And the other one, it's a broad online marketplace for sellers to sell all their goods. Two pieces of the market. And I suppose if that is accepted as the relevant market by the court, then you might be able to argue that they're a monopolist, that they have monopoly power. But the fact of the matter is that I, at least, haven't yet seen it defined that way. I've seen market definitions like an online seller of ebooks, right, that they have monopoly power in ebook sales, or they have monopoly power in certain segments, because for each of these items that Amazon sells, there are alternatives. And those alternatives may be different depending on what type of item it is. They may be broader, they may be narrower depending on the item. So it's going to depend on how that market's defined, and that's something the FTC is actually going to have to support and prove in this trial, the proper definition of the market.
I mean, if you had to be on one side of this case, would you rather be on the FTC side or would you rather be on Amazon's side?
You know, I think I'd rather be on Amazon's side. And the reason I say that is because I think this is a tough case for the FTC to win to start. And I'm not saying that they can't, because facts matter, and we don't know what the facts and the evidence are yet. It will matter what they prove in court, what the experts say, and what the testimony is, and what Amazon's documents look like. But I think the reason I ultimately come down on Amazon's side is because I don't think, if liability is proven, that ultimately those remedies are going to be particularly drastic. I don't really see a structural breakup. What I think will happen are behavioral changes. Amazon, you simply can't do this anymore. You can't push a seller way down in the search results simply because they don't use your fulfillment services, or you can't force them to provide the lowest price on Amazon.com. And very interestingly, Amazon's already promised to do most of that in the UK and in the EU. So it clearly is willing to change some of its rules and change some of the way it treats sellers in order to make these lawsuits go away. But the FTC didn't accept those concessions.
But the FTC in this suit, unlike even mentioning it in the Google suit, is not seeking a breakup of Amazon.
Well, we don't really know yet. I'd say that they haven't specifically said that, but their language is vague. You know, they're asking for a permanent injunction, and they're asking for the court to do what it needs to do to stop the monopolistic conduct. And really what that means is it gives them leeway down the road after liability is proven, because that's obviously the first step, to actually seek a remedy, which is a breakup. And normally when these kinds of cases are brought by the DOJ or by the FTC, they don't explicitly state what they're looking for in a remedy early on. That comes later. And I think they still could ask for something like that.
So Amazon's general counsel said if the FTC gets its way, the result would be fewer products to choose from, higher prices, slower deliveries for consumers, and reduced options for small businesses, the opposite of what antitrust law is designed to do. And that's what I'm saying about how can you beat Amazon for getting it to you the next day?
Well, you know, this is why I say I think this is an uphill climb for the FTC. It's really difficult to argue against the pro-competitive aspects of the company. I mean, it has created a very efficient, very consumer-friendly marketplace, essentially, that consumers love. They do get low prices. They do get speedy delivery. They makes it very easy. There's one-stop shopping. This is all
and
good.
Returns.
And returns, exactly. And a lot of help, by the way, when there's an issue with the product, because I've done that myself. So I think that when you look at monopolization cases, they're based on a reasonableness standard. So what a judge has to do is they have to weigh sort of the harm against sort of the pro-competitive side. And whichever side wins out, that's where you land, whether you violate the law or not. Is it a reasonable or unreasonable restraint of trade that we're looking at? And I think that when you have strong pro-competitive justifications for what you're doing, it makes it harder for a plaintiff, even the FTC, to win a case. And so I think you just put your finger on the head of what the issue is here.
Is this the third time that the FTC is suing Amazon this year or recently?
Something like that. The other suits are all consumer protection suits. So this is their first antitrust suit against Amazon. The others were on their consumer protection side, quite different from this.
Fewer states joined the Amazon suit than the Justice Department's suit against Google or the FTC's earlier suit against Meta. Is there a reason for that?
You know, it's very difficult to say. The states probably were all asked, and they weigh the pros and cons of being part of a suit. They tend to be more political, the state attorneys general, let's say, than the FTC. I think, and some of them may be more concerned about consumer perception here, that consumers tend to really like Amazon, whereas I think the perception about Google is maybe less positive generally when you look at consumer polls. And they also do see the pro-competitive side of Amazon's business. So I think that's probably why you see fewer states joining here than in the Google case, but they could still join going forward.
it's been in business 30 years. Do you think that Amazon sees this as a real threat to its business?
I think that any time you're sued by the Federal Trade Commission, it's a risk, right? And your documents, your information, your executives are exposed to what's mostly public trial. It's always a risk, and it can bring bad PR to the company. They certainly have to be somewhat unhappy about it, but I don't think they view it as a long-term major risk to the company.
Talking about Lina Khan, and they have tried to get her recused from the cases against them, right?
Yes.
Didn't work.
It didn't work. So they tried to get her recused because it was clear what her position was about Amazon back in 2017. And that's why we've all expected this lawsuit for so long, because we knew that her view was that this company behaves illegally in an anti-competitive manner. The issue is that she's not the one who's going to make this decision. This is in federal court. So she's acting as a prosecutor. And when you act as a prosecutor, that is what you do. If she did a new investigation of Amazon looking at the same facts that she looked at 3 years ago, I don't think she'd come out any differently. Where a lawsuit is brought internally at the FTC, that can be a different matter, because ultimately the commissioners are the appellate panel for that. An administrative law judge makes the first decision, and then the appeal goes to the commissioners, and they are acting as judge. And in that kind of an instance, I think it would have been different with respect to recusal. But in this instance, where it's out of her hands now, she's just prosecuting, presenting the facts, presenting evidence, some other party, the judge in this case, will make the decision. I think it's less impactful.
Earlier this year, the FTC challenged Meta acquiring the virtual reality company Within and lost that. FTC also lost a similar suit attempting to block Microsoft's acquisition of Activision. So how much will this case define Lina Khan's career?
I think those two cases are quite different from this one. Different standards. They were pursued under a different antitrust statute. And to be fair, by the way, the FTC is still appealing the Microsoft Activision decision, so it's not completely finished yet, even though I do think the companies will be able to close that deal. I think these more than those. This one. Amazon case more so than those two, because it's just a long time coming, and it's been her goal to try to pull the way antitrust laws have been interpreted back to the way they were interpreted more like in the 1960s. There was a big change in the 1970s and 1980s in the way the antitrust laws were interpreted and then in the way that enforcement played out. And her view is that because of that change, antitrust enforcement became too lenient and too lax, and that we have to go back to where we were sometime before the 1970s, where we really looked at market structure and just made a presumption that if a market was concentrated, it was likely to cause harm to consumers, rather than looking at whether prices to consumers are going up or output is getting lowered, but putting the structure aside. So even if it's an oligopolistic structure, so long as prices to consumers are low and output stays up, we're okay. And she's trying to bring it back to where it was, and I think this suit is a big step in that direction. As those two merger suits were, but they were sort of baby steps, this is a big step.
And we'll see just how this big step goes for the FTC. Thanks so much, Jen. That's Bloomberg Intelligence Senior Litigation Analyst Jennifer Rhee.
I will be working alongside humans to provide assistance and support, and will not be replacing any existing jobs.
Are you sure about that, Grace?
Yes, I am sure.
It was the first human-robot press conference. In July, a United Nations tech agency assembled a group of robots that look like humans to answer reporters' questions about the future of artificial intelligence.
I think my great moment will be when people realize that robots like me can be used to help improve our lives and make the world a better place. I believe it's only a matter of time before we see thousands of robots just like me out there making a difference.
That time is already here in many respects. Apple's Siri has been responding to your questions for more than a decade, and the release last year of ChatGPT has opened a worldwide debate about artificial intelligence and led to the filing of lawsuits over intellectual property rights. The latest, a proposed class action by more than a dozen well-known authors, including John Grisham and George R.R. Martin. against OpenAI for copyright infringement, calling its ChatGPT program a massive commercial enterprise that relies on systematic theft on a mass scale. My guest is intellectual property litigator Terrence Ross, a partner at Catton Muchin Rosenman. This is, I believe, the third lawsuit like this over ChatGPT. Tell us about the complaint.
So this particular lawsuit is brought by the Authors Guild, which is an association that represents authors for various reasons. And here they have taken the position that OpenAI's ChatGPT, which is an artificial intelligence system with a learning module built in, so that it can actually improve its ability to function by learning. But the Authors Guild has alleged that feeding the ChatGPT the works of its authors to help it learn, and then the ChatGPT using that to answer queries, which often involve quoting passages from the author's works, is a copyright infringement. And the lawsuit is brought as a class action on behalf of a very large class of authors here in the United States. And it'll have to be determined at some subsequent date during the litigation whether or not it's a legitimate class action or not. But it's essentially all the authors in the United States suing OpenAI, the owner of ChatGPT, over how they're using the author's works through ChatGPT.
In another suit brought by authors last month, OpenAI moved to dismiss the complaint and argued that the training basically constitutes fair use. So it seems like their defense is going to be fair use.
That's absolutely correct. And fair use is a statutory provision in the Copyright Act of 1976 that provides that in certain instances, copyrighted work can be used for secondary purposes that society deems as worthwhile, useful. The most important from your perspective is for news gathering and news broadcasting. But teaching is one of the expressly listed types of uses, secondary uses, that would be considered fair use. And it's a very interesting defense. Now, the statute, Section 107 of the Copyright Act, actually says nonprofit educational purposes. And that may pose a problem to OpenAI because I'm not sure if this would legitimately qualify as a nonprofit educational purpose or not. But it's a colorable defense, quite frankly.
We talked last term about the Supreme Court's decision in the Warhol case. That reined in the scope of fair use. So do you think that courts are likely to maybe rein in fair use in this case?
So I'm not sure that the Warhol case is going to have any impact on this case whatsoever. I think the Warhol case does rein in the uses of the defense of fair use on the margins. But as I understand the defense being raised by OpenAI in these lawsuits, it's really at the core of fair use. The statute was intended to protect certain types of secondary uses, and it listed examples of them. It's not all-encompassing, it's not exclusive list, but one of the expressly listed purposes is nonprofit educational purposes, and therefore this is at the core of the fair use doctrine. And I really don't see how the Andy Warhol case will limit that in any way.
The authors claim that ChatGPT can produce works that mimic their books, and there are businesses that sell prompts allowing users to create what's essentially works of fan fiction.
That's exactly what the concern here is, and in one sense, the fair use defense being raised by OpenAI is really diversionary. They are saying that they are feeding all of this data into ChatGPT so that it learns, and part of that process of feeding data into it is feeding into the machine entire novels as well as fact-based works, which have lower copyright protection, but it's all being fed in purportedly so that the machine learns. The problem is less with that, in my view, than what happens after it learns. It's the output of ChatGPT that is the problem. And when it, in response to queries, quotes copyrighted works, or on behalf of a query from an individual creates a purportedly original work that incorporates copyrighted language or large portion of a copyrighted work, That's copyright infringement in the classic sense, straight up and up copying. And that is the core problem here, that there is no apparent restraint on ChatGPT from doing that in response to queries from individual users of the machine.
And there's also a question of whether you can get a copyright on works created by artificial intelligence. And there was an interesting first-time ruling on that by D.C. federal judge Beryl Howell. Tell us about that.
So the whole area of artificial intelligence is raising a host of problems for intellectual property law. The Authors Guild lawsuit against OpenAI is one aspect of that. Another aspect is whether the creations of ChatGPT or other AI-type machines is protected by intellectual property. And so a gentleman by the name of Stephen Thaler has an AI system that he refers to as the creativity machine. And it created, according to him, an autonomously generated piece of visual art, i.e. a painting, which the machine entitled A Recent Entrance to Paradise. It's actually quite attractive painting. And Mr. Thaler applied for copyright registration with the United States Copyright Office on behalf of the creativity machine, reporting to the Copyright Office that the painting had been autonomously generated by his AI machine. And the Copyright Office rejected that application on the grounds that copyright only protects creations by human beings. Mr. Thaler appealed that ruling to the United States District Court for the District of Columbia, where the Copyright Office is based. And that court just issued a very important opinion of first impression, saying that artificial intelligence is not entitled to claim copyright in anything it, quote-unquote, creates, going further to say that human authorship is an essential and required part for a valid copyright claim. It's a very important decision in this field of artificial intelligence and will almost certainly be appealed to the D.C. Circuit.
I mean, was the judge on solid ground?
So Judge Howell's decision is actually really quite good. The D.C. courts do not often see copyright cases. It's just a simple fact. We've talked about this before. The bulk of the copyright cases come from the Second Circuit, New York, and the Ninth Circuit, California, specifically Los Angeles. And so this was unusual. And it's a really outstanding decision by Judge Howell, in which she lays out the history of copyright in the United States. She points out that James Madison in the Federalist Papers referred to authors as being persons. And that's important because after we actually got the government up and running, he was a congressman in the House of Representatives. He was on the committee that drafted the first Copyright Act. That Copyright Act, very first act, uses words like executor, administrator, administratrix, he, she, which seems to imply that copyright is held by humans. The 1909 Copyright Act expressly described the right accorded by copyright as going to a person. The 1976 Act, the one we currently operate under, has multiple references to people. For example, Section 203 of the Copyright Act says, when an author is dead, and that's a quote, thus implying that the author has to be a human. It uses the terms widow, widower, surviving children in connection with succession of ownership of copyright. These are all indications that the judge points to in the history of copyright that indicate that copyright is limited to human beings. Of course, we had that famous case a couple of years ago, I think it was the Ninth Circuit, Naruto versus Slater, about a monkey selfie. A monkey had somehow, I guess, accidentally triggered a camera and taken a picture of himself, and the Ninth Circuit said, no, that doesn't work, that human beings have to be people who get copyright. So there is this case law as well as the text of the language of the statute which supports this notion that it has to be human beings. I mean, we've had this long history of copyright having to deal with new technology. When photography first came around, there was lots of questions about whether a photograph was copyrightable. And the Supreme Court said, yeah, it is, because there's a human who's involved in controlling the process and making decisions like lighting, poses, how to develop it. And that was sufficient human involvement to justify photographs being copyrightable. In more recent days, computer programming. The human being writes something called source code. A computer then translates that into object code, which is quote-unquote machine-readable code, so the computer can actually process it, bits and bytes, 100110. And the courts have said, well, that again involves human development and control, and the computer is merely translating the human actions into machine-readable code, and so that's copyrightable. But now we're at a point where we're saying, at least in this case, that there was no human interaction, that this painting was autonomously generated by an AI machine. And Judge Howell makes an important point that human activity is required even when technology is used to some extent. Raises a lot of questions for the future, but I think there's a decision score easily hold up on appeal.
Terry, I'm curious. So when Thaler made the application to the Copyright Office, was it in his name? He was asking for a copyright for himself?
No, he was asking for a copyright on behalf of his creativity machine. He was asking for a copyright on behalf of the AI. Now, an interesting thing happened after this case came out of the Copyright Office and was taken to the district court in D.C. All of a sudden, Mr. Thaler started talking about, well, he issued prompts to the AI machine to do this. And Judge Howell said, well, that's not the record before me. The record before me is you reported to the Copyright Office that the AI autonomously generated this painting, and under that set of facts, there's going to be no copyright issued because machines can't get copyrights, only humans can. But it leaves open this question, and one of my colleagues here, Kat, has argued that there may be a point at which there are so many human prompts to the AI that the resulting work is copyrightable, because it fits into this notion in the history of copyright that some human activity and control is required. Now, the question is, how much of that is going to be required in the context of AI? A few prompts probably isn't going to be good enough. So talking about the Authors Guild case, if some high school student says, write an essay for me, and the machine writes the essay, is that sufficient of a human prompt? Probably not. And to the extent that it then just regurgitates something from a copyrighted novel that's out there, such as John Grisham's work, that would indeed be copyright infringement on the part of both the student and the AI machine. So I don't know where the courts are going to draw that line, or whether they will at all, whether they just say, no, AI is never going to be entitled to copyright registration, or at some point they say, well, if you give it 1,000 commands, maybe that's sufficient to get you, not the AI, but the individual who gave the commands, the copyright registration.
Have there been a lot of other federal court judges ruling on AI and copyright?
This is the first of its kind. We lawyers call it a case of first impression. And why it's so unusual that it's here in the District of Columbia instead of New York or Central District, California, or Los Angeles, is that the Copyright Office is located here in D.C., and so you take appeals from their decisions to the D.C. District Court, and it'll work itself up to the D.C. Circuit Court, which gets a copyright case maybe every other year. So again, they'll be writing on blank slate, and I assume this will go all the way up to the Supreme Court eventually, and we'll see what they say.
Coming up next, I'll continue this conversation with Terrence Ross, and we'll talk about patents and artificial intelligence. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Terrence Ross of Catton, Muchin, Roseman about intellectual property and artificial intelligence. This is copyright. How is patent law handling AI?
The issues of artificial intelligence are not limited to the copyright realm. The same gentleman whose AI created work was involved here, Stephen Thaler, had previously applied for a patent with the United States Patent and Trademark Office on what he claimed was an invention developed by an artificial intelligence. And the Patent Office followed a similar route to the Copyright Office and said that no, machines can't be inventors for purposes of the patent laws. Only humans can, and rejected the patent application. He took that on appeal to the United States Court of Appeals for the Federal Circuit, which is where you appeal decisions of the Patent Office. And the Federal Circuit agreed 100% with the United States Patent Office and said only humans can be inventors for purposes of patents, and affirmed the decision of the Patent Office. Mr. Thaler, apparently having unlimited resources, then filed a petition for writ of certiorari on that decision with the United States Supreme Court, which just this past spring denied that petition. So the law is, on the patent side, the same as on copyright side, that humans are the only ones who can be listed as inventors on patents. Indeed, this goes back far in time. Every now and then corporations make the mistake of applying for a patent in the corporate name, and the patent office says, no, only the inventor, the human can. They can then assign the patent to the corporation, but corporations can't be inventors, only individuals can. So it's consistent with past patent office practice. It's consistent with the approach taken on copyright. So we're starting to see this evolution within intellectual property that comes to the same point, which is that only humans are entitled to intellectual property rights in the United States.
What about these robots that have the characteristics of humans? Can you get a patent on those?
Inventors can get patents on an artificial intelligence system, just as they can get a patent on most other computer software. AI is usually more than just software. It's usually some sort of system. So there may be a method patent as well as utility patent on it. But no, I'm actually representing someone right now who has obtained a patent in the AI field. The really interesting question, though, is this. We're seeing the use of artificial intelligence in a lot of activities that traditionally are considered creative. One example is in coding, writing software programs. There are now artificial intelligence programs that help programmers to write code. You set up a framework of some sort. You say, I want to do this in this section of the program, and the AI writes that code. Similarly, in Hollywood, we see in movies and television, artificial intelligence doing special effects and providing and being involved in some elements of a production. Indeed, the recent writers' strike and actors' strike had at their core demand by the unions that AI be prohibited in movies and television. But in both these contexts, in the use of AI to help in coding, the use of AI to help in film and television, now that we know that AI-generated work is not copyrightable, what impact does that legally have upon the computer programs, the motion pictures, the television shows that have used artificial intelligence as part of the creative process? All of a sudden, is Star Wars deprived of its copyright because artificial intelligence machine helped on portions of it? Is a software program or a video game, which is essentially a software program, are they, because they've used AI to help in the coding, have they lost their copyright? I mean, this is a really important legal issue that a lot of companies rushing to use AI have not considered. The question is whether in the act of employing AI to help in the creation of your work, you're losing the ability to obtain copyrights. I mean, this is, for studios, this should be something that's on the front page of their agenda of things to think about. This has to be on their radar screen. I've never understood why they were so opposed to the union demands on artificial intelligence, because in effect, by incorporating AI, they're taking away the most valuable asset they have, their copyrights in their motion pictures. And it's something that you don't hear much discussion about.
Maybe that will be the next topic we hear a lot about. Thanks so much, Terry. That's Terrence Ross of Catton Muchin Rosenman. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.